3, second reading.
Senator Edwin Sifuna.
Thank you, Honorable Chair. Honorable Speaker, as you may know, I am a member of the Senate Energy Committee. I rise to move this amendment bill as a proud member of that committee that is chaired by the Senator for Nyeri, the Honorable Wamatinga. Honorable Speaker, in March of 2023, at a sitting of that committee on energy, there was a resolution by the committee to conduct an inquiry into the high cost of electricity. Mr. Speaker, this is an issue that many of us in this House have interacted with. Honorable Speaker, this is an issue that had, at that particular moment in time, occupied many discussions around the country. When we began this process, Honorable Speaker, at the point at which this inquiry was initiated, Kenyans were buying Kenya shillings 100 at that particular moment in time would get you only 3 units of electricity, Mr. Speaker. That in fact, out of 100 shillings, 51 shillings were going to taxes and other charges and levies. Mr. Speaker, the committee did conduct a proper inquiry, including meetings with various stakeholders. I remember the then Minister for Energy, the Honorable Chirchir, stakeholders from Kenya Power, from Ketraco, stakeholders from the independent power producers, and others appeared before the committee. And Mr. Speaker, there is a report of the committee that was, there's a report of the committee that was prepared in September of 2023. I don't recall the exact date when it was tabled in this House, but Mr. Speaker, it is a matter of record in this House that in fact that report has been tabled before this House. Honorable Speaker, if you allow me to go through some of the observations and recommendations of the committee, and I do this because those observations and recommendations out of that inquiry are the ones that informed the proposed amendments to the Energy Act in order to seal some of the gaps that we found as a committee. Honorable Speaker, at the, on page 7 of the report where it has the chairpersons forward, and allowed me just to read. Honorable Speaker, one of the things that the committee noted is that there is a general opaqueness in the disclosure of the beneficial owners of power producing companies, with the majority of them listing companies, foreign companies, as shareholders. There was another observation, Honorable Speaker, at paragraph number 12, that the dispatch of power currently done by KPLC is not based on least cost merit order. Therefore, preference is not given to the cheaper power producers. Honorable Speaker, another important observation that informed the amendments is that at paragraph 20, you will see the committee says that some power purchase agreements provide for mechanisms of discounts once a certain threshold is met. For example, Lake Turkana Wind Power Limited offers 50% of the energy charge rate once they attain the discount energy threshold. And Lake Turkana Wind Power did appear before the committee, in fact, in a meeting that was held in this very chamber, and attested to this, Honorable Speaker. They were, in fact, protesting that Kenyans were being denied this benefit, yet that the benefit is actually woven into the power purchase agreement. If you go to the recommendations, Mr. Speaker, on page 8, flowing all the way to page 9 and 10, there's a recommendation there that Kenya Power should dispatch power based on merit order, giving preference to the cheaper power producers. Honorable Speaker, this amendment bill is not complicated and it's not long. Mr. Speaker, there are only 3 proposals in this particular amendment bill, and as I have read to you the recommendations and observations of the Committee on Energy, they actually all flow from those recommendations and observations of the committee. If you look at clause 2, Honorable Speaker, of the amendment bill, I have proposed that an amendment be inserted in the Energy Act immediately after section 134. So this will be the new section 134A, that requires a generating entity to enter into an energy purchase agreement to sell electrical energy to a licensed entity specified in the third schedule. And then we go to what that a generating entity must consider when entering into such an agreement. Honorable Speaker, we have introduced the principles of public finance enshrined under Article 201 of the Constitution into the decision to enter into a energy purchase agreement. And these principles, Honorable Speaker, are openness and accountability, public participation in financial matters, good governance to ensure that public funds are used in a prudent and responsible way, sustainability, Honorable Speaker. This is as a direct result of the feedback that we got during the sittings of the committee to inquire into why these electricity bills are as high as they are and that Kenyans are complaining that something needs to be done. As you saw, Honorable Speaker, there was a clear manifestation of opaqueness in how people determine whether we in fact need to enter into fresh power purchase agreements. So, Honorable Speaker, we have introduced a requirement there that prior to procurement of electrical power, there has to be a feasibility study that is conducted to identify whether there is enough demand for electricity purchase which cannot be met by the existing production. Honorable Speaker, we were told, if you look at your power bill, there is something called a capacity charge. That capacity charge is charged on every consumer of electricity for all the capacity that has been contracted by Kenya Power to supply power. And that capacity means, Honorable Speaker, every time you issue a license to a power producer, for as long as that capacity to supply is there, we are paying for it whether they are actually dispatched or electricity is actually bought from their generating units or not. So, Honorable Speaker, the committee felt, and this is what informed my amendment, that before you give any other person a contract on purchase of power so that they are setting up any new plants, a feasibility study must be conducted to tell Kenyans that, in fact, the existing capacity cannot meet the requirements at the particular moment. Honorable Speaker, if you look at 134A 3B, there is also a requirement to ensure the process of procurement of electrical energy complies with the procedures set out in the Public Procurement and Disposals Act. Mr. Speaker, what we have seen in the past is there is really no openness in how these people who hold these power purchase agreements ended up as suppliers to Kenya Power, because the public is seldom informed, and there is no information at all when they are being procured, on what terms, and it requires an inquiry of the House, such as the one that we conducted, for us to even know the terms that they have been given. So, Honorable Speaker, we have introduced that amendment to ensure greater transparency. Then, Honorable Speaker, as was noted by the committee, it is something that doesn't make any sense, that you have cheaper available power, but yet the person who is responsible for dispatching electricity at Kenya Power decides to go for more expensive sources of electricity, such as those thermal generators, Honorable Speaker. And evidence was given here, I have alluded to it, by Lake Turkana Wind Power themselves, that in their PPA, and we go to see that PPA ourselves, if a certain threshold of uptake is reached, we can enjoy as high a discount as 50%. But as of the time when they were appearing before us, that threshold had never been met, because for some reason, and Kenya Power themselves will explain to the public why that is the case, they are never given that priority to be able to pass that benefit to Kenyans. Honorable Speaker, there is a proposal there again to tie the hands of Kenya Power so that priority is given to those who generate electricity through renewable technology. Honorable Speaker, this morning, the team from Talo, Kenya, appeared before the Senate Committee of Energy to discuss the field development plan for the Lokichar Basin. Honorable Speaker, from the evidence that was given by the management of Talo themselves, there is a recognition across the world that now people are moving away from fossil fuel energy, and that in fact we are struggling. The reason why the field development plan and the exploration in Lokichar Basin has delayed, Honorable Speaker, is that funding and money and credit for the development of oil fields have dried up because of the increasing awareness on the need for us to cut down on fossil fuels, and many people are now moving towards investment in green technology and green energy. So they are struggling. The management of Tullow themselves told us today the money has simply dried up. There are very few investors who are now willing to put money into oil exploration. Because if you look at places such as the EU, Honorable Speaker, and other places, there has even been a moratorium that has been put that beyond 2030, vehicles that operate using diesel or oil-based fuel, Honorable Speaker, will be phased out, and therefore there is a move towards greener sources of energy. So, Honorable Speaker, we want even Kenya Power to give priority to generating entities that generate through renewable technology. And we gave the example of Lake Turkana wind power. We have Kipetro as well, and even the solar generators should be given priority as opposed to those who generate using heavy fuel oil, which is very expensive. The last amendment, Honorable Speaker, or the second or third one, Honorable Speaker, on the disclosures, the committee noted that many of the IPPs that have, Mr. Speaker, can I get some? Honorable Speaker, as was noted by the committee, many of the IPPs that hold power purchase agreements as we speak today, Honorable Speaker, have not fully disclosed their ownership. And in fact, it was a struggle for us here in the Energy Committee to even get to know the beneficial owners of some of these companies. There is a great suspicion amongst members of the committee and in fact the larger public that wherever there is secrecy as to the ownership of a company, we would not be surprised, Honorable Chair, to find, and as a lawyer you know, people hiding behind shell companies and claiming that this is a company that is operating out of India, for instance, and yet the true owners are people here in the ministries and in government. So therefore, Honorable Speaker, one of the recommendations we have made is that the Kenya Power, or whoever it is that will be running our grid, can only award a power purchase agreement to an entity that has fully disclosed its beneficial owners. So that, Mr. Speaker, it should be standard practice. If you have something to hide, then we shouldn't be doing business with you. You should be able to tell us outright who the owners of the company are. Lastly, Honorable Speaker, would you believe it that even as a committee, we were very shocked to find out that we do not know as a country how many of these power purchase agreements exist. Nobody tells us, even as Parliament, how many of these power purchase agreements exist. There are people sitting on power purchase agreements just quietly. And, Honorable Speaker, we are paying for capacity charge for things that we are not even aware of, where they exist and where they're generating from. So, Honorable Speaker, the committee felt it important that we have a register of all the power purchase agreements that it has entered into, and Honorable Speaker, this must be published on its website and in the annual audit reports of the purchasing entity. The register in that subsection, Honorable Speaker, we require it to be prepared within 90 days from the date of operation of this section and be open to inspection by members of the public in accordance with Section 5 of the Access to Information Act. Honorable Speaker, lastly, we have provided that the authority shall not approve an energy purchase agreement which fails to comply with all these provisions that we are introducing. Mr. Speaker, with those many remarks, I beg to move. And I want to request the Honorable Stuart Mazayo to second.
Mr. Speaker, I second.